say that Mr. Jacob Zuma cannot stand. Let's say you say that because that's your view. That's fine. You are entitled freedom of expression. You can say whatever you want. But you cannot tomorrow sit as an arbiter of that very question. You can't. You know, so if you might hold a view about Mr. Zuma's eligibility or not eligibility. Either you keep it to yourself, but if you're going to express it, then by that act, you are disqualifying yourself from pretending to be a neutral arbiter the following day. Imagine if an arbitrator was to declare which of the parties is responsible for this or whatever the dispute is. And then the following day he says, okay, now you can address me. The party who's holding a newspaper, they say, but Mr. Arbitrator, I see here, you said the car does not belong to me. And he says, no, I was just stating the law. What is that? No, you can't do that. So that's the first issue. The second issue is that mercifully, our learned friends at paragraph 20 of their affidavit, where we thought they might fudge the issue and try to get out of it, actually assisted us. That is page 281. They say that
page,
was
what page?
281 at paragraph 20.
The affidavit of Mpofu.
Is the answer? Is their answer to our yes? Thank you. It says, that was not prejudging Mr. Zuma's eligibility to stand in the election. And this is what they say. Ms. Love simply stated the correct legal position. Moreover, her statement was made in response to a question about Mr. Zuma's eligibility. I mean, this is the IEC itself saying under oath that Ms. Love's statement was made in response to Mr. Zuma's eligibility. They might as well have said under section 47(1)(e). And then neither Ms. Love nor anyone raised the Mr. Zuma's eligibility on their own accord. That's irrelevant. So they confirm that she was talking about Mr. Zuma's eligibility. And all I'm saying, Justice Matopo, is that that is the very question which then serves before her. Number one. Number two, it turns out that they actually lied about this not being a confirmation of an existing position under oath. So the court cannot really want to use technicalities to run away from a criminal offense. The people who say that the commission did not decide, at least not before the decision, that Mr. Zuma is not eligible to register as a candidate. But a week before, they said it's official, former President Jacob Zuma cannot be the president of the country, and so on. Therefore, this provision, then they quote section 47(1). Therefore, this provision renders former President J.G. Zuma, not some other person, disqualified to be on the list of any party contesting an election or to contest as an independent in the upcoming elections. Really, can it ever be clearer than that? That this was, I mean, Justice...
So the short submission is, if we are with you on that point, the decision of the IEC is tainted because of the bias of Ms. Love, and also the passage that you've referred to us in the affidavit.
Yes. Remember,
and on that basis only, we don't have to consider the other points.
That's quite a thing. If on that basis only, that basis is more than enough. If someone has lied to this court under oath, I don't think it can be described as only. Because, I mean, that's the worst thing you can ever do. But let's assume it can be, you could say, well, it's like saying, I'm sentencing you to marry because you only stabbed someone. It can be. What we're saying, Justice Matopa, is very simply this, that these transgressions the original transgression of prejudging the matter. And this transgression that has now come out. And remember, this current transgression is provoked by the fact that Ms. Love now in this court, unlike in the previous court, puts a confirmatory affidavit, in other words, confirming these lies. And then we say, okay, well, if you're going to accept her answering a confirmatory affidavit, surely, in terms of audi alteram partem, you must give us a chance to refute that lie. And we refute it with evidence that shows that it is not true. So it's not only, it's one of the most egregious forms of litigation. Sorry.
Mr.
Sorry.
Yeah, maybe I'm wrong to try to interpret what my colleague Justice...
We're not interpreting anything today.
No. Justice Mpofu said, but I understood the only, not to make light of
thank you.
the point we're making, but rather to say that this point puts paid to the IEC's case. That's how I understood.
Oh, yes. No. Thank you. Then I'm sorry. If that's what the question would be, yes, of course. Remember, we said all of the matter. So if the electoral court had found in our favor on bias, that would have been the end. Or if they had found in our favor on ultra-virus, that would also have been the end. So if that was the question, yes, we definitely, in other words, if the only means you can decide the case only on that point, yes, then the answer is definitely yes. But what I was...
you've answered me.
Yes.
Yeah, can I just finish my last question?
Yes, of course.
Is it your submission that the judgment of the electoral court can exist side by side with the judgment of this court, the contempt?
Well, it was not this morning, but it is now, because you have found, I'm reading between the lines, that this case is not about any interpretation or judgment, so to speak, on the other.
Perhaps let me put it very clear. Is the judgment of the electoral court saying what this court said in the contempt application?
No, it's not it's not saying the same thing, but what it is saying, Justice Mpofu, is this. It's like, let's say this court had said that someone is not fit to be a lawyer or something at a particular point in time. What the electoral court was saying is that does that judgment, as it stands then, for example, mean that this person now is not eligible to be a lawyer or a doctor or whatever it is? And it is in that sense that I was saying this morning, it is inevitable that this court has to interpret that judgment, just as it was inevitable for the electoral court to interpret this, the judgment of this court. It's inevitable.
But if the judgment of the electoral court makes findings that cuts across findings that were made by Contempt J in the contempt of court, can it exist side by side with that judgment?
Yes, in the following manner, Justice Mpofu. If the question before the electoral court, for argument's sake, was whether the committal for contempt by this court was committal for contempt, and they say no, it was not, then they would be second-guessing this court. But that's not what they were doing. What they were doing was to say, is that committal for contempt of court, for the purposes of the thing before us now, which is 47(1)(e), a a conviction per section 47(1)(e). And that's why they're all...
Can they do that?
Yeah, of course they can, because...
But doesn't that seem to nullify the judgment of the contempt of court judgment, if it does?
Yes, it would nullify it in my first example. But in this second example I'm making, it doesn't nullify it, because it does something very banal and simple. It says, what does the word convicted mean in 47(1)(e)? Just like that. And does it mean a conviction as contemplated in section 35 or not? If it does, then this conviction cannot be the one that was intended. I don't want to go to intentionalism, but let's use purpose. Then the purpose of the intentionalism is actually brought by the wording that says contemplated, because obviously that brings in that element. What they were saying is that the purpose of the disqualification did not include that which the Constitutional Court did, rightly, let's say, for argument's sake. Constitutional Court did what it had to do, it was correct, it was okay. But that which it did does not translate, and that's where the case becomes simple.
But if you read the judgment of the Electoral Court on its own,
Zondi JA.
Yeah, on Zondi JA, and without comparing it or analyzing it with the judgment of this court, the debate that you and I are having, it's not in that judgment.
No, it is. It is. They say...
In paragraph 51, Zondi does not even interrogate the issues as extensively as you are.
Yes. No, but...
So one has to assume that this is what he says.
No, Justice Matopo, with respect...
Am I wrong?
No, with respect, you are. That is why I said, let's use the issue of appealability as a proxy. The issue of appealability must not be used as a red herring to hone into that issue. It is a proxy for the denial of the 35(3)(0) right. But it is also a proxy for the denial of all the other rights in 35(3). And therefore, what the Electoral Court was saying was that a so-called sentence which does not conform with 35(3)(0) and S versus Rance and S versus Twala and all these other cases which say that there must be a reappraisal of cannot be a sentence that was contemplated in 47(1)(3). In doing that, they were not denying the clear fact. If they were denying that clear fact, they would never have gone to the remission point, because what would have been remitted? Nothing, because Mr. Zuma was free. No, that would be absurd. They accept that this is what happened. And that's why they go on to say, having defined the conviction is. The question is simply this, Justice Matopo. Can anyone here say that, and I'm using the language of contemplation deliberately, that it was within the contemplation of the drafters that a conviction which does not conform with the Bill of Rights would pass muster? Or, to put it differently, as Cameron J.A. put it, can anyone contemplate that a committal for contempt in civil proceedings would result in a previous conviction? And in both cases, our respectful submission is no. So that's all they were saying. So let's assume they were interrogating that question only, whether it's a previous conviction. If they found that it is not, they would not be second-guessing this court. They would simply be saying a committal of this nature does not belong to the SAP 69. Without that does not mean that then they're saying that committal was wrongly granted. No.
So the conviction and the sentence you would characterize them as not ones that fall within the realm of the SAP 69?
Oh,
Or-
yes. No, yes. No, I'm saying,
As-
yes, I'm saying this, that very question that you're posing to me, Justice Matopo, is the question that was left open by Justice Cameron in Faki. And all I was saying, I'm not taking it any further. I'm not even answering that question myself. I'm simply saying, by the mere fact that Justice Cameron, in that matter, saw it fit to leave that question open and to relate it to Section 35, which is what I have done. By that act alone, it shows that it's not a straightforward issue. Because if it was, he would have said, he wouldn't even have referred, he would have said, these people, I don't know what they were smoking. They come and say, is the conviction a conviction? Obviously it is. But no, he entertained it exactly because it's not as straightforward as it looks to the naked eye. He interrogated that question and posed it posited it, as it were, for a future.
But wasn't it answered
in which matter?
In the Contempt judgment?
No.
My brothers and sisters said.
No, it was not answered because that's why I was saying
Or
to
it did not
Justice.
arise.
Well, I don't know if this court, remember in the magistrate court, what happens? You would know, Justice Matopo. A long time ago, we used to do these things together. But in the lower courts, even the high court, let's say, when the sentencing happens, then that court, it is the duty of that court to then enter the record, so to speak, into and process this SAP 69 and so on. That's why Justice Cameron says, what mechanism would be employed? Because this would be a civil court now. A civil court, does it have the mechanisms to enter a sub 69? And I doubt it. I won't put it higher than that. I doubt if this court, after the Khambebe judgment, took those steps.
You prove a previous conviction by your SAP 69, if indeed there are.
Correct. And if it's not there, you can't.
Okay.
Okay.
Oh, poor Mr. Mpofu. Thank you so much. No, I'm just commiserating with you.
Well, no. No, you don't have to, Deputy Chief Justice. The only problem is that I have this flu, but it's gone now. I think the adrenaline kicked in. No, we're indebted to the court for the interaction, and the order that we seek is obviously whether it is based on the counter application is gone now, whether it's based on the acceptance of that the conviction was not a conviction for Section 713, or that the sentence was not a sentence for the purposes of that section, or if the court doesn't like those, the mere fact that the remission, the presidential remission of sentence, obviously had the effect of reducing the sentence, assuming it was a normal sentence, quote unquote, or what Justice Khambebe called a conventional sentence, assuming it was those, the effect of the remission would have been to reduce it. If the court is against us on all those three issues on the merits, we still say that the court will have a duty to examine where the IEC derives its power to deal with the holding of office, which is a province of the National Assembly. And if they're against us even on that, then the bias point with respect on these facts is unanswerable, because I don't think there's anyone who can ever say that a body, a so-called independent body at that, can do what was done here. So on either one of those bases, we respectfully submit that the appeal be dismissed with cause.
Thank you, Mr. Zuma.
Thank you, Justice.
Deputy Chief Justice, I mean, it's 15 minutes past 8, and that's not a joke.
Yeah.
So I don't know what you want to do, whether you want me to just press ahead or you want to take some time.
Ahead, please.
All right, thank you. I'm going to try to really be succinct. I think that it's been oppressive to all of us. So the first point is the purpose of the disqualification. We've dealt with the purpose of the disqualification in our heads of argument, and we've referred to paragraph 168 of the Venice Commission report. Nothing to add there. The second question is whether or not contempt of court should be among the offenses or the crimes that are hit by Section 47. We say yes, and probably even more so for contempt of court, because contempt of court, you will recall, is a crime against the administration of justice. That's really the essence of contempt of court. And if there was a case where Section 47, which is people trying to become our public representatives, if there is a case where Section 47 should apply, it is contempt of court. Because it's a crime against the state, it's a crime against the administration of justice, it is a crime against the rule of law, it is a crime against the Constitution. And the primary duty of MPs is to uphold the rule of law. So their intentional defiance of court orders is inimical to that purpose. So in this debate about whether or not contempt of court should be within or outside Section 47, there is a very strong normative case that it should be within the ambit of Section 47. And we see this court in paragraph 87 of the contempt ruling, where it makes the point clear. It is almost crying for help when it says, if the impression were to be created that court orders are not binding or can be flouted with impunity, the future of the judiciary and the future of the rule of law would indeed be bleak. So if we rewarded people that are guilty of contempt of court with seats in parliament, imagine what would happen to the future of the rule of law. The third point is around this double punishment theory. There is no double punishment. This is not a punishment. It is akin to the reasons for the striking of a lawyer or an attorney or an advocate from office. The reasons have nothing to do with expressing a moral opprobrium in relation to what they did to their clients, whether they stole money or not. The reason is to protect the public. Particularly where at the time of the striking off, they still display no signs of any reformative character. So the same object is achieved by Section 47. It is not a punishment against Mr. Zuma. It is simply to protect the public and the institutional integrity of Parliament. Number 4, there is the issue of ripeness. Let me spend a little bit of time on this. The powers of the Commission have been much discussed. It is Section 30 of the Electoral Act that applies. Section 30, subsection 1A, says that any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds. 1, the candidate is not qualified to stand in the election. Now, that phrase, not qualified, tracks back to Section 47 itself, because Section 47E, the last sentence, says a disqualification under this paragraph ends 5 years after the sentence has been completed. So it's a disqualification provision. But it is put into operation by Section 27, subsection 2, subsection A, which says that if you want to contest an election, you must submit a list. That list must contain an undertaking signed by a duly authorized representative of the party, and it goes on and on. That undertaking is contained in page 147 of the records. So you will see it page 147 of the record. That is what that undertaking is. It's Appendix 2. This is what it says. Justice Gamble, you raised this point, but never really went to the actual annexure. But this is where it is at page 147. This is what you undertake. I declare, under 8, I declare that I have confirmed that each candidate on the list is qualified to stand for election in terms of Section 47 and or Section 106 of the Constitution. Section 47 applies to the National Assembly. Section 106 applies to the provincial legislature. So this is all a pre-screening process prior to anyone being nominated for the National Assembly. So plainly, it's an obligation of the Electoral Commission that it must screen candidates for qualification under Section 47. But there is a fundamental conflict in what is being submitted on behalf of MK, because they say that you qualify, you are eligible to stand for an office that you cannot hold. And they say, well, the solution is Rule 13 of the rules. When they have to explicate what Rule 13 is about, what they say is that in the first meeting of the newly elected National Assembly, the first order of business is the election of the Speaker. But the question is, who is electing the Speaker? In order for you to elect the Speaker, you must be eligible to be in the Assembly. So they are not answering the question, they're begging the question. So there is a straightforward answer, and not the contortions being suggested by MK. Number 5 is the question of bias. Now, there are 2 documents. The first document is at page 272 and 273. That's the document that quotes Ms. Janet Love, and the actual quotation is at page 273. And it is, this one is mine, yeah. So this one says, that she says that excludes anybody who has been given a sentence that was not the subject of any deferral. And in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy. So it's a neutral statement that doesn't really take matters anywhere. Then what happens is that when the matter came before this court, new evidence was then introduced, which is at page 493. It now appears that the fulcrum of the bias case is on the new evidence. So page 493 and 494 was not before the Electoral Commission. It's new evidence introduced in this court. And it's introduced without an application for the introduction of new evidence. So it's impermissible. It's pro non scripto. It should not be taken into account at all. So the only issue that was before the Electoral Court is page 272 and 273. And as I say, it's a neutral statement that takes matters nowhere. And the Electoral Court, at least on this score, cannot be criticized. And you will disregard entirely the supposed references to page 493. We didn't respond to it.
Mr. Mulatobi, sorry to interrupt you. Didn't the applicant, in terms of an additional affidavit by Ms. Love, and I forgot to ask you about this earlier, also introduce a new affidavit? And my question is, this is an appeal.
Yes.
Shouldn't it be decided on the basis of what was before the Electoral Court?
Indeed. We agree entirely with that. You can disregard the confirmatory affidavit of Ms. Love, and you will be left with one document, which is page 272 to 273. We agree fully. I'm out of time, Justice, Deputy Chief Justice. I have only one more point, so if I could ask for a minute. Thank you. It is in relation to the case of Disanaike. We listened carefully to what is being suggested. It's actually not correct. The correct finding is at paragraph 8.5 of that judgment. What it finds, what the actual committee found, it did not find that the principle of excluding candidates who have a criminal record is necessarily unfair. It found that the period of exclusion in that case, which was 7 years, was disproportionate. So it was decided on the principle of disproportionality. So you will see this where it says, given that these restrictions rely on the author's conviction and sentence, which the committee has found to be arbitrary in violation of Article 9, Paragraph 1, as well as the fact that the state party has failed to adduce any justification about the reasonableness and/or proportionality of these restrictions. The committee concludes that the prohibition on the author's right to be elected or to vote for a period of 7 years after conviction and completion of the sentence are unreasonable and thus amount to a violation of Article 25B of the Covenant. So it was on the disproportionality of the period of disqualification. I have already made submissions in relation to what the remission means and what the appeal proviso means. There is no point in repeating those. Deputy Chief Justice, I want to thank the court for the patience, and we have no more submissions to make.
Thank you very much, Mr. Mbeto.
Sorry, Mr. Chair, I promise you I'm not exercising my right. I would have normally had a right to reply on the cross appeal, but I'm not exercising that. Just wanted to make a reference that I had promised to Justice Bilkis. It's at page 223, where I was talking about the issue of, the heading special remission of sentence for certain categories. So that's what I was saying, it's not a general, of sentence offenders, correctional supervision, parole. And then there's the list of 13. And in that list, it says sexual offenders, murderers, attempted murder, crimes, criminal lifers, child abuse, and so on. And they don't include contempt of court.
Thank you. All right, thank you all so much for your submissions, and we do apologize for keeping you for such a long time on a Friday. Judgment is reserved.
As court visits.